some time or another in their life they are going to purchase something or involved in a contract of sale, especially when it relates to a house or a piece of land. Just listen to what it says here. The South African law of purchase and sale has come down in uncodified form. That means it's not written down, it's uncodified. From Roman law via Roman Dutch law. So there was Roman law, then the Dutch, when they came into the Cape of Good Hope in 1657,
Yes.
and the 14th of February, or April, I beg your pardon, 14 April 1657, the first deed of sale, the first transfer of, or deed was taken place, title transfer took place then. It has undergone remarkably, listen how they write this, it has undergone remarkably little change. Normally I regard remarkably as something of a massive change, but they say remarkably little, so it's basically inconspicuous. It's really no change whatsoever since the 17th century, which is not really surprising in view of the following. First, the development of rules relating to contracts of sale was one of the most remarkable achievements of Roman jurisprudence. Secondly, during the 11th centuries between Justinian's codification and Jan van Riebeeck's landing at the Cape, this construct was progressively refined. So it started as uncodified, then they started to code it, and they regard it as they call it, a statutory construct. It's something that's built, but it's built with words and concepts in the mind of men only, or in the mind. Excuse me. The construct was progressively refined in day-to-day practice and studied, analyzed, and commented upon by generations of jurists of great erudition. While thirdly, the economic function which contracts of sale were required to fulfill remained basically unchanged, even though economic life became increasingly sophisticated. For more than 300 years, therefore, the South African judicial system has been called upon, as far as the contract of sale is concerned, merely to cross a few T's and dot a few I's. For the rest, answers to questions which arose could be, and indeed were, found mainly in the treatises of the Roman Dutch authors of the 17th and 18th centuries. Those legislative provisions which have been introduced over the past 50 years or so to meet the perceived need for consumer protection, as far as they relate to contracts of sale, have for the most part taken the form of restrictions on a seller's power to impose unreasonable incidentalia on his buyer, and have left the essentiale and naturalia of the contract largely unchanged. So with whom lies the obligation? It lies with the seller. And in terms of what we perceive today, the obligation lies with the buyer. Unless you provide the money, you don't get anything. When in fact, the existence of an obligation has been I can't get the word that I wanted to say. It's depending the existence of an obligation, and it subordinates the existence of your unlimited commercial liability under a contract, or to make the contract execution possible to a future determinable time over 20 years or whatever the case might be, with the result that you lose the security of your person as a security interest that leaches out, and you keep on running the hamster wheel. They basically say it. It's not my words. But you go in and the first thing you see is an offer to purchase. Why do lawyers give you an offer to purchase to sign, when in fact you should accept a firm offer to sell in the first place? Those documents are not are not drawn or drafted in such a manner. The static nature of the law of sale presents a problem for any writer attempting to describe the fortunes of such contracts since 1806. The fortunes. Should only the relative few developments that have taken place be included, or should a holistic approach be adopted? I argue that the durability of the basic features of the contract of sale is in itself of historical interest, and therefore I do not limit the description to those aspects which have undergone change, but present as fully as possible within the confines of this article an overview of the current law of purchase and sale in South Africa. Because people say, we are in South Africa, so what do you try to say with it? If you understand the law, it doesn't matter where you are. We are now at the forefront of a globalized system that's going to be implied in South Africa as well. Whether you like it or not, it's going to happen. At the outset, it should be mentioned that according to South African law, all contracts are consensual. That means they need your consent at all times. Contracts of sale, therefore, in principle, derive their binding force from the mere agreement between a buyer and a seller, as was the case in Roman and Roman Dutch law. For the validity of a sale of immovable property, and this is where Fani and Linda is stuck now, and his buyer. For the validity of a sale of immovable property, a further requirement has, however, been introduced by legislation. So unless you understand the legislation and unless you understand the provisions made in terms of that legislation, you're going to run yourself a gauntlet. You might just get yourself in a very tight spot indeed. Because the contract must be in writing and signed by the parties or their agents acting on their written authority. That means you can do it as the two parties only, but we don't. We always have an agent in between, and that is the lawyers. And that's talking about the transfer of title, that we should stop lawyers to transfer title without knowing exactly what goes on. De Wet and Van Wyk define a contract of sale in modern South African law as a reciprocal agreement by which one person, the seller, undertakes to deliver an object, res in commas, to the other, the buyer. Now please explain to me, how do you deliver a piece of land with a house on it to someone else? How do you do that? There's something else. It's called an object, and it's called a res, R-E-S, and that's a piece of paper only. And the latter undertakes to pay the former a sum of money in exchange for the object. So if you understand that 25% of all money circulating as capital in this country is in coin and notes, and the rest is commercial paper only, then you should get the message. It's an exchange or transfer of paper for paper. And if you understand the negotiability of that paper, and you understand the law of negotiable instruments, you might just be lucky that you can take that piece of paper, the title document or the document of title, which is a negotiable instrument, and if it's handled properly, you can deposit it somewhere and it might have the value that you expect it to have. But people are not familiar with that concept. Or they think I'm from another planet. It's all here. It's just a question of going through it. According to this definition, there are only two essentials for a contract of sale. Only two. Namely, the undertaking by one party to deliver an object and the undertaking by the other to pay a sum of money in exchange. That's it. Now why do you always have that they want you to make a provision for the payment of money before the first note is delivered? Why? Because it puts you in an unfair advantage. It puts you in the debtor position when in fact you are the sponsor of the credit in the first place by original issue discount of that specific instrument. And they talk here later on about the discounting, that when a bank discounts the instrument in good faith, the holder in due course has preferential treatment. Hello? But no one knows what the holder in due course is, because they don't know how to deal with the bill.
Yeah.
This view has its roots in the works of the institutional writers. Institutional writers, write things with a specific objective in mind. Thus, Van der Lindens described the contract of sale as the agreement, listen to this, the agreement to transfer a certain object for a fixed price to someone else. Therefore, if you transfer something, a deed of sale, transfer of title, offer and acceptance, fixed price, you cannot accept an offer unless the price is fixed. Then it's still negotiable. The moment the negotiations are over and you say, I accept that price, that's it, it's a fixed price. It's over and done with. These two essentials are sufficient to distinguish a contract of sale from any other contracts. Now, that's on page 362, and Jan Lot said that when they asked him to do the essay on purchase and sale. Now, I refer you back to what we said about the South African Reserve Bank own notes, where they speak about the fact that it distinguishes this contract of sale from other contracts.
Yes.
So there's a differential advantage when you deal with negotiable instruments, when you deal with a monetary system. You do not deal with legislation pertaining to companies and to insolvency specifically. There's a specific rationale for that, and that's because they tie in here the law on negotiable instruments that no one wants to recognize or understand or fully apply, because once you apply that, it's a settled deal. Consensus, sometimes mentioned as a third essential. To have consensus is not even, although it's required in South African law for the validity of any contract, it is not a specific characteristic of contracts of sale. The position mirrors Roman Dutch law. Therefore, in South African, as in Roman Dutch law, a seller's undertaking to deliver an object to the buyer does not involve an undertaking by him to make the buyer owner of that object. So if you end up with the object as a piece of paper giving the equitable title to the state and the beneficial title to someone else, you are not obligated or given an undertaking to basically transfer or to deliver the object to the buyer. It doesn't involve the undertaking by him to make the buyer owner of that object. And that proves my point that I said to you, you're not the owner of your land. You're a beneficial user. You're a tenant. You're really a tenant on the land because you don't understand where it comes from. And I'm saying it with respect. I'm not referring to you. I talk about most people. Say to me, well, it belongs to me. I've got cart and transport. Yes, you have, but you pay taxes on the land, which means it's not yours. I don't pay tax on my property. It does, however, impose on him the duty to transfer all his rights to the object, including the right of ownership, if it vests in him unreservedly to the buyer. Why would they put that in if there's a possibility that it wasn't really the case?
Ja. Daar's die proof wat hulle vir jou gee wat jy werk. Die proof.
But then a lawyer writes a letter and he says cordially on behalf of a legal firm, and he lies through his teeth. And cordially means with respect and with warmth. It's time that we consider where these terms come from, what these people try and do. Because a lawyer acts as trustee, that's why he wants the money transferred into his trust account. To do what with? Why? First of all, because the whole thing is mirrored around the other way. They depend the existence of the obligation of the seller, and they subordinate the existence of your unlimited commercial liability under the contract or under the execution of the contract of that value to a future determinable time, which is 20 years, and they do it with a clause that's written in that document that you sign in good faith, that the lawyer pushes over the table towards you and say, there's your deed of sale, and the consequences thereafter.
You have to study these things and learn it exactly, or every word that you've done.
Or just apply it.
Yeah, I mean, but
it's like someone who buys a new fridge. You don't buy a fridge to know how it works. I don't know how a fridge works, but I know the function that I want to, and that's what we need to do. We need to just get to a point where you understand the negotiability of negotiable instruments, what they refer to, why they call them instruments, and look at the processes that govern those commercial processes. And then it becomes helpful in two ways. First of all, you can then confront any institution to say, but hang on, this instrument that you provided me with is an incomplete instrument. Are you familiar with it, with the fact that it is? No one signed it. So you can then take ownership of that document by becoming the holder in due course, by being an endorser, or being an acceptor, or even the signer of an aval, which is made provision for in the Bills of Exchange Act. Now please correct me if I'm wrong. Tell me I'm a lunatic. Tell me that the Bill of Exchange Act was written for someone else very special except myself. And that the Amendment Act of 56, the Amendment Act 56 of 2000, was not written to make provision for protection of the users. So the moment you utilize that legislation and you apply it appropriately, it gives you protection. It's guaranteed. It's not perhaps, it's guaranteed.
Sure. Okay.
I spoke to someone yesterday. I asked her, because I bought a stamp, a rubber stamp, and I said to her, are you familiar with the Bills of Exchange Act? She said no. I said, well, how can you sell this to me then? And she was stunned. But those are the obstacles, those are the things that keep this from us. Where people say, but what do you do at Pick n Pay? If Pick n Pay's payment system was geared accordingly and appropriately to be honourable in terms of the Bills of Exchange Act, you would just sign for your stuff. You would never have to do anything other than sign for it. But the payment system is not geared towards that. The payment system is based on the National Credit Act and the implication that you will go and apply for credit from a financial institution without using your security of person, but allowing them access to your security of person without your knowledge, and then they will do a fractional reserve lending formula on that and loan out much more than you ever signed for initially without your knowledge. And you will be on the short end of the stick, and you will have a security interest derived from your security of person for someone else, but they never put the interest into circulation. And that's why it's like musical chairs. And that's what I find despicable, that someone can brag and say, I just did a 400 million rand deal, but they don't understand what they really did, in fact, was escalate the South African national debt with another 400 million.
Yes.
If you borrowed it, it's a different story. You know, some people say, well, I have the money. Fantastic, it's part of the national debt. It's not money. It's a negotiable instrument. It's a concept. It's a trust. And it's a debt trust. And it's currently funded by the IMF, and they are basically sitting, drooling, waiting to bring in their special drawing rights against our security of person. From an international perspective, not from a local perspective. And that's how far we've transgressed, and where we need to dig into it. And where people that give lectures and seminars and make people pay more than 8,000 rand to find out how to establish a public trust need to understand that you don't need that in the first place. Your name is a trust already. It was created when you were born. And it's regarded as an inter vivos trust. It's a living trust. You're not dead yet. But when you go to a court and you look at the court procedures and what they do, it resembles a probate issue. It resembles a burial, or where someone's estate has been called upon.
Can you maybe short explain what they do with your name and how they misuse your identity?
I think we did that.
You did that?
We can speak about it again.
And more depth and more understandable. How do we do it then physically?
Okay.
The way we're doing it.
My understanding of it is that, as I said, when I came out of my mother's birth canal, I couldn't read a calendar. So now, today, if someone says to me, do you have any conscience against the oath or giving the oath? And I say no, then it's expected of you to speak the truth, the whole truth and nothing but the truth. And what they do in the court systems is it's like a trap. It's literally a trap. Unless you come back and say to me, I'm mistaken, I'll accept that. But I perceive it as a trap, and the way I dealt with it in my own presentment or presenting myself with my restricted appearance at the court, it proved it to me beyond any shadow of a doubt. In fact, I didn't even use that. There was something else that came in. But essentially, when you go into the dock, it's the dock is also metaphorically a dock where a ship berths. And they talk about our berth, B-I-R-T-H, but a ship as a berth place, B-E-R-T-H, where it goes into the dock, and then the shipmaster or the captain signs a manifest to the dockmaster to proclaim or to declare what is the cargo on the ship. Now this is what happened to us when our mothers docked in the hospital, or the dock was there, and through the breaking of the water, this little vessel came down the birth canal and it came to the bank. It was then registered as cargo in a trust, and that trust was named similarly to our name with the birth date, and it's written in all capitals. So you sit with a name that is capitalized on in terms of Roman law, where they basically in capitals, you have no rights whatsoever. As Mandela House referred, they will be stripped of their rights and given a commercial value. Now it's easy to do that on paper. You just register that entity with in a capitalized style in terms of the Roman law of way back then, and you've got a slave. And now you allocate a commercial value to it, and now you can start using that as collateral, as security, to basically float your fiat paper currency. And he said that's the only logical way to fund governments, by registering liens and debt to the registrants, and basically make you culpable of pledging something that you can never pay because our substance has been taken away from us.
Yes, in
the gold and silver.
Yes.
Now, we were prepared for that in 1920, and my birth certificate is done in terms of Section 40 of Act 17 of 1923. And on my birth certificate there's two words, revenue /inkomste. Excuse me. And as far as I'm concerned, that relates not to revenue, it's a revenue. I've been revenued out of the private sanctuary of my mother's womb into a hostile public venue, into a republic. But at one stage we were living in a constitutional republic. But since 1994, things have happened behind the scenes, so we're now so-called living or residing in a democratic republic, which is an oxymoron. What is the difference between a constitutional republic and a democratic republic? Have you ever thought about the implications? What does it mean?
Yeah, well, the democratic one is everybody's got to say the people rule the land, isn't it?
No, not really. Might be a perception. Let me give you a simple example of a constitutional republic versus a democratic republic. In a democratic republic, there's two foxes and a sheep, and they are going to vote tonight what's for dinner. Two foxes and a sheep.
Okay.
And they're going to vote what's for dinner tonight. So who do you think is going to win and who's going to end up with dinner?
Natuurlijk is dit die arme skaap.
Right. So the two foxes, the majority rules
Yes.
that what's for dinner tonight is little sheep. And sheep doesn't now have no say in it whatsoever.
Even if he have a say, it will be counted out because he's...
Correct. In a democratic situation.
Okay,
Yes.
yeah.
This is what people are so proud
Okay.
about now.
Yeah.
Say, well, I live in a democracy and I'm a very law-abiding citizen and taxpayer.
Yeah.
Right. So that's the one aspect. In a constitutional republic, the sheep has a gun. That means in a constitutional
Yeah.
republic, even if 99% of so-called voters decides to do something, it does not negate the rights of a single individual man or woman. And that's the issue. That's what we need to reconsider. Is the Constitution, as far as I'm concerned, is a document of no authority. It's there to keep a de facto government in place that was put in place by deception because we don't know who we are
Yeah.
and what our unalienable moral rights are, not civil rights. I'm not fighting for civil rights. I don't have any civil rights. I have moral rights,
Yeah.
which are unalienable,
Yes.
and I waive any benefit privilege. So if you make an implication that a civil right can be defined also as benefit privilege, it can be taken away from you. And
Yes.
that's why people fight for it and they die for it. I don't need to die or fight for my unalienable rights. I don't need to prove that I live. I live. I don't need to prove or beg for my freedom. I am free. I do not ask anyone permission to utilize my own property. It is my property, and I express it as such. But people go and they register, apply, and submit forms, and they submit themselves to another man's law form. Why would you do that? Why do you submit to another man's law form? Especially if you don't even understand the language they use to put the laws in place then. At least do some due diligence.
Because they want me to feel that I'm breaking the laws if I don't. But whose laws is it in any way?
Correct.
And
Correct.
who said it's the law?
Correct.
And who said I must submit underneath?
Correct.
The law, but
There it talks about one of the fundamentals of any contract is consensus. So if I don't consent to it, it's not applicable to me. And then we're forward, and some people say, so do you take the law in your own hands? So no, I don't. I don't need to. But I know what my rights are. And we will apply some legislation now to certain issues that will assist us in getting the remedy and the recourse that we so desperately need in this country. I'm talking about the geographical area of South Africa. And it's high time that people make that paradigm shift.
the more people making that decision, the more the system will tumble.
Well, we hold the current system in place. Yes, it's not, to me it's not even tumble. It's just it will evaporate like it started off, very conspicuous. And we'll get back to a point where I believe, and Professor Leonard Gerem, before his death in 2007, it is just something. Let me see if I can find it quickly. He was referring to I want to read you something that he said. I hope it's in this book that I often think about things that I thought about. No, I don't think it's... Yes, here it is. Just listen to this. Finally, work was started in 1983 under the auspices of the South African Law Commission to bring about a complete revision of the Bills of Exchange Act. The project was led by Professor Frans Malan of the Rand Afrikaans University. A scholarly report inviting comment was eventually published in 1988. As yet, however, none of the suggested reforms have been implemented. Instead, an attempt has been made to politicize the issue. In his preface to his book published in 1993, Professor Leonard Gering states, and I quote, "I am of course aware that proposals have been made on behalf of the South African Law Commission to replace the Bills of Exchange Act of 1964. I venture to suggest that when for the first time, and hopefully in the near future, there will be a government in South Africa based on the will of all the people of this land, not the majority, of all the people."
Yes.
That refers you
Yes.
back, people on this land is common law. So he talks in codes. Its priorities will be taken, the priorities will be to address the vast social and economic problems affecting the lives of millions of citizens. Civil law. There's a code, there's a distinction in the terminology that he uses. And not to replace a statute based on the English Bills of Exchange Act, which has been referred to as the best drafted Act of Parliament which was ever passed. In any event, the South African Law Commission itself will no doubt require a transformation.
Sure.
So even shortly before his death, he was not prepared to relinquish the fact that we are being controlled by a system of civil law, and that we have lost the ability to discern the fundamentals of common law and of our unalienable rights that was established with the first covenant with the creator of this race called humanity on this planet.
Yes.